It's great to see such a nice crowd here today. I'm going to try to project my voice to the back of the room, but if you aren't able to hear me, you can either come to the front because there's plenty of open seats, or just raise your hand and I'll try to project a little louder, or as a backup, I can use a handheld mic as well if you can't hear me. So as Kelly said, my name is Sarah Helvey, and I'm a staff attorney and director of the Child Welfare Program at Nebraska Appleseed. And those of you who may not be familiar with Appleseed, we're a nonprofit, nonpartisan, public interest and legal advocacy organization. We're based in Lincoln, but we do work statewide. Our program areas are child welfare, as I mentioned. Then we do work in the area of poverty and public benefits. We do work in the area of healthcare access and then immigration policy. And I'm really happy to have had the opportunity to partner with Cassy Rockwell from Project Everlast in our little statewide tour with the spring lecture series. So with that, I want to give just a little bit of a roadmap for what we're going to talk about today. We're excited to have a nice 3-hour chunk here, but rest assured, you will not just be sitting in your seats listening to a PowerPoint. We're going to mix it up and have some practical application sections as well. So we're going to start. I'm going to give just a background on the Bridge to Independence program, including the statutory provisions, and then I'm going to go over some resources that we've created for to help young people and professionals as the Bridge to Independence program is implemented. And then Cassie's going to jump up and do a piece on positive youth development, including the 6 C's of youth development, youth-adult partnerships, and then she's going to touch a little bit on brain development. And then we'll get into small groups, and we have a nice group here, so I think that'll work well. We have several case scenarios that will give you an opportunity to kind of talk through what this program might look like and some kind of typical hypothetical examples of young people. And then we're going to do a little bit of team planning. We have a team planning guide which has some questions for your jurisdictions to consider as this program is implemented, and we'll walk through that as a group as well. And at the very end, I'm going to jump back up here and give a little overview of a new provision of the Affordable Care Act for youth formerly in foster care, makes them eligible for Medicaid to age 26. Okay, so first the Bridge to Independence program. That's a picture of Jacob with your Senator Crawford from this area. And I'll talk a little bit more about the role of young people in passing LB 216, but they're there in the lobby of our state capitol when LB 216 was being debated. So as you know, the outcomes for the population of young people who age out of foster care are unfortunately not great. Less than 2% finish college, over 50% experience homelessness, and many others struggle with access to employment, health care, and ultimately poverty. But research has shown that programs like the Bridge to Independence program can help improve those outcomes, and that was one of the impetus for starting this program in Nebraska. And then in terms of the data in Nebraska, about 300 young people each year exit the foster care system without achieving permanency, so without being reunified, adopted, or guardianshiped. About a third of those are discharged to independent living before reaching the age of majority, and then about 2/3 of those age out of the system, so they're age out of the system at age 19. And then there's a little bit of data there on the former ward program. I'll talk a little bit more about the status of the former ward program, but another impetus for the creation of this program in Nebraska is that the former ward program, while it has been helpful to many young people attending post-secondary education, has some restrictive eligibility requirements, and so there was an interest in creating a more comprehensive program. So the Federal Fostering Connections Act, as I'm sure many of you know, in 2008, created an option for states to draw down federal matching funds to extend foster care to age 21, and that's what this program, Bridge to Independence, is part of that. I always say more than a dozen other states have created programs like this, but I recently heard that number is closer to 22 or 23, and so Nebraska is joining a growing list. There are federal requirements for the program, but there's also flexibility, so the programs vary a little bit state by state. And then the process that led to the creation of this program in Nebraska, as I mentioned, was a really inclusive and I think thoughtful process. Several years ago, the Nebraska Children and Families Foundation established a stakeholder group, brought together representatives of all three branches of government, young people, advocates, and providers to talk about what a program like this could look like in Nebraska. That was facilitated by the Jim Casey Youth Opportunities Initiative, and that stakeholder group developed, again, program design recommendations for what a program like this could look like in Nebraska, and then based on those assumptions, a fiscal analysis was conducted to get a projection of what a program like this would cost in Nebraska. There were also surveys conducted with over 250 stakeholders across the state, and surveys and focus groups were conducted with young people across the state. So as I said, this was really a youth-driven process. In addition to the surveys and focus groups, young people were involved in every step of the process, from providing input on the bill's language to testifying at the hearing on the bill, speaking at press conferences, speaking to their senators, and then young people were there at the Capitol on all three rounds of debate on LB 216 and also LB 853 this year. So it was really a highlight of my career to see so many young people engage in this process, and many of them, this program wouldn't even personally help them because they were beyond the age of 21 or for whatever reason, but they were really determined to improve the system for the young people that came after them. So that's something that I think we can all be really proud of as a state. So as I said, LB 216 was passed last legislative session. It was introduced by Senator Amanda McGill from Lincoln, and it's codified at Nebraska Revised Statute 434501 at SEC, the very end there. LB 216 established an advisory committee with, again, representatives of all three branches of government, young people, and other advocates. And the advisory committee was tasked with developing initial and ongoing recommendations for the implementation of the program. And that also was, I think, a really inclusive process because there were several work groups that were established under the advisory committee, and that brought in additional stakeholders and advocates to give input on the various aspects of it. The advisory committee sits under the Nebraska Children's Commission and submits their recommendations through the Nebraska Children's Commission. And then under LB 216, the department was required and did file a state plan amendment by October 15th of 2013. And then under the statute, the program is to begin within 60 days of the state's receipt of notice of the federal government's approval of the state plan amendment. And so that's a little complicated. Everybody's wondering, when is the program going to begin? As Kelly mentioned, the governor signed the regulations last week, and so we're hopeful that the federal government will approve the plan soon and that the program will begin soon, again, within 60 days after the federal government's approval. And then there was proposed regulations when I wrote this PowerPoint, but they're now effective and they're at 395 NAC 10. And then also, as Kelly said, this session, there are two bills introduced related to this program. The first is LB 853, and that's essentially a cleanup bill and also implemented some of the recommendations from the advisory committee. And then LB 908, as you may know, is a bill that created guardianships under the juvenile code, and that includes a piece about extended guardianship assistance to age 21 under this program, which I'll talk a little bit more about. Okay. So now I'm going to walk through the basic eligibility requirements of the program. Young people must be adjudicated 3A and in an out-of-home placement at age 19 or discharged to independent living. So this does include young people who were duly adjudicated, but unfortunately at this time does not include young people solely with a 3B or delinquency. I've been asked the question, would young people be eligible if they had they had a 3A adjudication, but it was not open at the time they aged out. They had a 3B, and I think the answer to that question is it depends on how the 3A case was closed. If they were discharged to independent living, they would be eligible for the program. And then young people must also meet at least one of the following requirements. This is federal language. I think of these as the education and work requirements. They must be completing secondary education, enrolled in post-secondary education, employed at least 80 hours per month, participating in a program or activity designed to remove barriers to employment, or unable to do any of those things due to a medical condition, which can include a mental health condition. The services for young people as part of this program include Medicaid coverage, case management services, and those are enumerated at Nebraska Revised Statute 434505, and that includes a number of things, including but not limited to helping young people, for example, apply for post-secondary education and aid for post-secondary ed, help them connect with relatives and support systems, help them get their records, sealed juvenile court records. There's a whole list in there. I don't have my notes, but there's a list of those things that case management can help young people with. And then also, young people are eligible to receive the continued foster care maintenance payments to provide housing support for the following housing options. They can remain in their foster home. This also created a category called the supervised independent living setting, and that can include single or shared apartments, houses, host homes, or dorms. And then young people could also remain in an institution or foster care facility, but only if necessary due to a developmental level or a medical condition. Okay, and then there are several oversight mechanisms, and these are also federal requirements, or kind of options within federal requirements is a better way to say it. In Nebraska, there are annual permanency reviews, and those are held at least once per year and at additional times as reasonably practicable at the request of the young adult, HHS, or any other party. And those are conducted by the juvenile court. And then there are 6-month case reviews, and those are held every 180 days. Those will be conducted by the Foster Care Review Office, and the goal of that is to evaluate progress, that the young person's progress in helping them meet the goals of their case plan. And that's in collaboration with the young adult and other individuals identified by the young adult. And then it's also a federal requirement and state requirement that young people may meet face-to-face with their independence coordinator. I think I failed to mention earlier that the caseworkers in this program will be called independence coordinators, so they're required to meet on a monthly basis face-to-face with their independence coordinator. Okay. The federal program also requires that when states extend the foster care assistance to age 21, that they also extend adoption and federal guardianship assistance. And so young people who were adopted or entered into a guardianship with a licensed relative at age 16 or older are eligible to receive Medicaid and the extended guardianship or adoption assistance to age 21. So the adoption piece of that is pretty straightforward. So young people who were adopted at age 16 or older are eligible to continue to receive the payments to age 21. The guardianship piece is a little more complicated. So the state can only draw down federal matching funds to extend guardianships that are federally eligible for 4E, and that includes those that are with a licensed relative. Unfortunately, Nebraska only has a few of those. I know the state is wanting to get more licensed guardianships, but for the time being, to try to minimize the disincentive to permanency that's created, LB 216 established, a state extended guardianship assistance program, and young people are eligible for this piece if they enter into a guardianship at age 16 or older that is not with a licensed relative. And young people that fall under this category are eligible to receive that extended guardianship assistance payment to age 21, but not Medicaid, to the extent possible within existing funds. And the legislature, unfortunately, due to financial limitations, only appropriated $400,000 for the biennium for the state extended guardianship assistance program. The legislature also specifically tasked the advisory committee with making a recommendation for maximizing and making efficient use of this funding. And the advisory committee made a recommendation that there be a public-private partnership to fully fund all guardianships that are at age 16 or older to age 21. And the recommendation was that be administered through right turn. And so my understanding is that there has been a commitment of those private dollars, but the details are still being worked out. Let me take a breath there because that was a lot, and that last piece in particular is complicated. So are there any questions? And if there are, we are being recorded today, so keep that in mind, and Sarah will come back with a microphone for the question. I think there is one in the back.
You had mentioned that the foster care facilities would receive, or the children within foster care facilities would receive these funds as well. Does that include the kids that are in shelter that are unable to find placement due to behavioral issues?
Now this is where I asked that there's a row of folks from the department in the back, and so I'm not able to answer that question. I would want to give them an opportunity if they can on that specific. Or we might have to follow up.
Hi. Yeah, emergency shelter is included as one of the approvable placements. So I think what the question that hasn't been answered is the shelters that are available to us, if they will take this population, and those details haven't been worked out. But to the extent that shelters placements are available and needed, yes, they are okay under this program.
Thank you. Thanks, Sarah. Okay. Any other questions that I can defer to the department? Just kidding. Okay. Feel free to just raise your hand and jump in as well. Okay, so this piece, I want to just kind of walk through what the timeline, kind of how this process works from beginning to end. The first step is the department is required to provide a written notice about the program to potentially eligible young people at age 16 who are in care at age 16, and every year thereafter, and then at least 90 days prior to the last court hearing before the young adult turns 18 or is discharged to independent living. A representative of the department also meets with the young adult to explain the program in person and how to avoid a lapse in services if the young person wishes to participate in the program directly after aging out. If the young person decides to participate in the program directly from aging out, that agreement is to be signed and filed with the court prior to that last court hearing. Young people this is a voluntary program. I should have mentioned that right from the beginning. So young people can opt in and opt out of the program anytime between 19 and 21, so long as they're eligible. And so young people, when they turn 19, and professionals are talking to them about the program, if at that time they say, and we've heard this from many young people, no thank you, I am ready to be done with the system, I want to be as far away as I can, they can decline at that time and decide to go out into the world. And if a few months down the road they are struggling and they want to come back in, they can do that at that time as long as they're eligible. And so if young people decide at that time when they're aging out that they don't want to participate, there's a requirement that the department provide them with information about what they're giving up by not participating in the program and how they can come back into the program at any time. And then similarly, if young people, they can opt out. So if they decide to go directly into the program and they age out, and a year down the road they're doing great and they're working or in college and they are not wanting to participate anymore, maybe due to the requirements, they don't have to stay in all the way to 21. They can decline at that time. Sorry. And then within 45 days of signing the agreement, an independence coordinator is assigned and the young adult begins receiving services. Also within 45 days, the department must file a written petition with the juvenile court, a copy of the signed agreement, a copy of the case plan, and any other information for the court's consideration. Also within 180 days of signing the agreement, the court opens an extended services and support file for the purpose of determining whether participating in the Bridge to Independence program is in the young adult's best interest and to conduct the permanency reviews. This program is structured as a voluntary placement agreement under federal law, and so that best interest finding within 180 days, within the first 180 days is a requirement of the voluntary placement agreement. Thereafter, the young adult continues receiving services and support. Permanency reviews are conducted by the court annually, or as I said, upon request, and case reviews are held every 6 months by the Foster Care Review Office. This is kind of explaining the opt-in, opt-out there on the left. If the young adult is determined by the department to be ineligible for the program, I want to explain the process there. I really like how the department has chosen to implement this, has interpreted this piece of the statute. If young people become ineligible for one of those education or work requirements, they have what I think the reg calls a grace period, so they have 30 days to become eligible, try to become eligible for one of the other categories. So say maybe they drop out of school, then they need to try to meet the work requirement. So they have a grace period of 30 days to try to meet another eligibility criteria. If they're unable to do that within 30 days, then the department gives them a notice that they're being terminated from the program, but there's 30 days notice before the services end. So they essentially have a 60-day period to try to retain their eligibility. And I think that that's really helpful just due to the fluid nature of young people and also this program, because they can come in at any time as long as they're eligible. So kind of eliminate some of that in and out, and is helpful to the developmental process of a young person. Okay, so I want to now just walk through, since this is the court implementation piece of the Bridge to Independence program, and I know we have lots of legal folks and folks that work in the court system here today. I want to just walk through some of the statutory language relevant to the court process. So, and some of it will be a review. Upon filing of the petition, the court shall open a Bridge to Independence program file for the young adult for the purpose of determining whether continuing in the program is in the young adult's best interest and for the purpose of conducting the permanency reviews. And then there's the best interest finding. The court shall make that best interest finding not later than 180 days after the young adult and HHS enter into the agreement. Again, the department is required to file the petition with the court within 45 days of the signing of the agreement. So the court essentially has 135 days there to make that finding. It does not have to be after a hearing on the record. It can be a paper review. And the language is the best interest to participate in the Bridge to Independence program under the Nebraska statute. And then again, the juvenile court shall conduct the permanency hearings at least once per year and add additional times. And then LBA 53, this legislative session, added that language, but not more times than is reasonably practicable. And that arose because an Omaha attorney that shall remain unnameless, friend, said, well, at one of a presentation, well, what if a young person requests a hearing every week? And I was like, that will not happen. And then some judges said, well, you know, that could become an issue, and really under the old language, there wasn't any restriction on that, and so that language was added to put, you know, some guidance on that this legislative session. And then there's also language in the statute that the juvenile court shall conduct the permanency reviews in an expedited manner and shall issue findings and orders, if any, as speedily as possible. And that's, I think, to reflect the fact that this is kind of really is a short period of time that young people would be in this program. And then the juvenile court may request, there's language in the statute that the juvenile court may request the appointment of a hearing officer to conduct the permanency review hearings under this program. And it references that 24-230. 24-230, I'm paraphrasing, but it essentially says that there can be hearing officers in juvenile court, but that the Nebraska Supreme Court shall promulgate a rule for the appointment of those hearing officers, and no such rule has been promulgated as of this date. I co-led a work group with Judge Johnson under the Advisory Committee on Case Oversight. I know some folks here were a part of that. Thank you. That group recommended that the Nebraska Supreme Court promulgate a rule for hearing officers in juvenile court, but no action has been taken on that time, but that is a possibility down the road. Here's just the language, so you can see it on the primary purpose of the permanency review, and that's to ensure that the program is providing the young adult with the needed services and support to help the young adult move toward permanency and self-sufficiency. And then there's some language about the active engagement of the young adult in the permanency review hearings. The court shall consult with the young adult at all permanency review hearings in an age-appropriate manner. regarding the proposed permanency and transition plan. The young adult shall have a clear self-advocacy role in the permanency review, and the hearing shall support the active engagement of the young adult in key decisions. And then this one, the permanency review shall be conducted on the record and in an informal manner and whenever possible outside the courtroom. So this is one during our team breakout that we hope that you'll have some discussions about what that might be able to look like in your jurisdiction. I will tell you, we've been to Holdridge and Hastings and South Sioux City, and the county judges were like, no, we cannot take our recording equipment to another location. But first of all, I have high hopes for the separate juvenile courts that you can be creative because there may be a higher volume of cases here. But also we can talk about, it doesn't, if it can't be in another location, we can talk about there's been a discussion of other ways that those hearings can be more informal, whether it's the judge not wearing a robe or another style of seating arrangement. So that'll be hopefully a conversation as part of the team planning portion of our time. And then in terms of the department's role in the permanency review hearings, the department presents a case plan to the juvenile court, and that shall be prepared at the direction of the young adult in addressing progress in meeting their goals and proposing modifications as necessary. And then this language is the department meets with the young adult at least 30 days prior to the permanency review hearings. As I said, the independence coordinator and the young person are required to meet on a monthly basis anyway, and so this is just requiring that at that monthly meeting prior to the permanency review hearings, there be some specific efforts to talk to the young person about so they know about the hearing, the date and the time, and what that process is going to be like, and help prepare to make the most efficient use of that hearing. LB 853 this session made an edit to amendment to 43-247 to include reference jurisdiction for this program, and so that there is a new subsection 11 of 43-247. Very exciting for the lawyers in the crowd. So these might be sub 11 cases, and those are the proceedings under the Young Adult Bridge to Independence Act. And then some language about the juvenile court's jurisdiction, and I'm just going to walk through this language. The court shall determine whether the Bridge to Independence program is providing the appropriate services and support as provided in the agreement to carry out the plan. The court has the authority to determine whether the young adult is receiving the services and support he or she is entitled to receive under the Bridge to Independence Act and the department's policies or state or federal law to help the young adult move toward permanency and self-sufficiency. And then if the court believes that the young adult requires additional services and support to achieve the goals in the plan or under the act or the department's policies or state or federal law, the court may make appropriate findings or order the department to take action to ensure that the young adult receives the identified services and support. Okay. Court-appointed attorneys. The young adult under this program can request a court-appointed attorney. The representation of the young adult would be under a client-directed model of representation, not best interest. The under 19 CASA's appointment may be continued with the consent of the young adult, but it would shift from a best interest model to a client-directed model of representation. The department is required to provide notice to the young adult as part of the written notice about their right to an attorney. And then there's also language that the court has discretion to appoint a CASA volunteer or continue the appointment with the consent of the young adult of a previously appointed CASA volunteer for the young adult as part of this program. Okay, let me just pause there and ask if there are any questions, because I went through quite a bit there as well. Yes. Oh, can you wait for we got a microphone coming.
You had mentioned that the monthly meetings are a requirement. So if a young person is not meeting that requirement, then would they be discharged from the programming? Because as we know, this population seems to change contact information quite frequently. So would they be dropped from the program at that point, or?
I I think that's another question. I think that that's not a component of eligibility for the program. I know in conversations with the department that they really intend to work with a young adult as much as possible to help accommodate them, and they know that it's a mobile group and that there going to have to be some travel involved. And so I think the intention is to try to be flexible and to try to work with the young people and come to them as much as possible. But I don't believe that that's a eligibility requirement, but I'm not sure how that will be handled. And I welcome the department to jump in if they have a rule on that. Be like, yes. Oh, is that a?
You mentioned that in the slide on appointment of attorneys, it says that there'll be an attorney will be appointed who is, I think, youth directed. In other words, it's representing the youth, not the best interest, and that they would, so long as they had received training appropriate to the role. I'm assuming you're referring to the attorney. Are there any plans for that in the works, or what does that mean?
Yeah, I mean, I think that that's talking about guardian ad litem training and attorney CLEs, but I don't know that there's any specific requirements that have been established by the Supreme Court or others about what the parameters of that receiving an appointment of this program should look like. Yes, we have one up here. Well, this is for the recording to pick up. So it doesn't actually project your voice, but it allows the camera to hear the question.
I think historically, regardless of what role one is in, GAL, attorney for parents, attorney for child, there's been a lot of difficulty in getting reports pursuant to the hearings that are scheduled submitted in a timely fashion so that there's an opportunity to address issues. Did the programming address that issue of timeliness of reports?
No, I don't. I mean, there's not, other than the timelines that I went through about when the petition is filed and so forth, there's nothing in the statute that talks about timelines for providing reports prior to hearing. It's a good consideration.
Well, I think we need
Generally speaking, yeah.
Yeah, I think we need to address that because, at least in my experience, it's been a major problem because a lot of times you've been handed a report a day or two before, if even that, and I think it makes it difficult to come to a considered, decision or approach if the reports by anybody are not submitted with enough time in advance of hearings or meetings to address the important issues. And I'd like to see that addressed somewhere where there are some definitive timelines.
Yeah, so for those of you who may not be able to hear in the back, he's mentioning the issue of receiving reports late or just prior to the hearing, and are there any requirements as part of this program? I think that's an issue that we need to probably look at generally, but I think you make a good point that in particular with this program, when it's just such a short period of time, continuances are gonna, if you have a continued hearing right there, are gonna not be able to get in within the intended annual hearing because it's really only a 2-year period of time that young people are in the program. Yeah. Yes.
So I'm assuming that the county attorney's office then is not going to be involved in these types of things. Is the prior docket then closed and a new docket open for this purpose?
Yeah, that's a great question. She asked if county attorneys are going to be involved, and she's correct that not as part of this extended program. And then if it's a new docket, and I should just add that into the talk because I seem to get that question every time. Yes, it will be a new docket. Where did Linda go? Because I know that's also been a concern for judges wanting to be able to reference. Are you able to speak to that, Linda? From NFocus. The court.
No, from Justice.
Or sorry, Justice.
That's okay. With Justice, when the petition is filed, the courts will open up a new case. It'll be a juvenile case, but it'll have the subtype of number 11 that goes along with 43-247. It'll come in as a closed case. So statistically, it will not be counted as a case. We will be keeping a query on it, though, so that we can see how many cases there are that are filed, monthly. There was another question you asked, wasn't it?
Just that the county attorney was no longer.
Right, yeah, the county attorney's not part of it.
Yeah, and I just want to speak to that because we had some county attorneys, I think, participating in other locations. And so while the county attorney will not be involved in the extended program, I think there is an important role for county attorneys just to know about the program in the under 19 system, because this is part of transition planning and making sure the young person kind of knows about this possibility that is incorporated to a certain extent in the under 19 system. So there's a role there, but not as part of the 19 to 21 case.
One of the other things that we're going to do is instruct the courts, because these juveniles, when they were a juvenile, they did have a 3A case. So we'll instruct the courts to cross-reference that juvenile case with this new young adult case. So if a judge wants to see that other file, that it can be pulled, and they can always, reference what's happened with that too.
Great, thank you, Linda. Okay, any other questions? Okay. I have now a set of questions for kind of the groups of professionals that will be involved in this case, including the CASA volunteers, attorneys, and judges. So first, for CASA volunteers, what is a CASA volunteer's role in the bridge to independence case? And so, as I said, the statute is specific that the guardian ad litem shifts from a best interest to a client-directed model. But I think for the CASA, because under the existing statute for CASAs, their role is to examine and provide information to the court regarding the child's best interest. And so I think that their role remains best interest, but I would argue that best interest in this extended program looks a little bit different. It's in the statute characterized as best interest to participate in the program and to receive those services and support to help them achieve permanency and self-sufficiency. So I think it's sort of a shifted best interest model. And then how does my role change if I was young adult's previous under 19 CASA volunteer? As I said, the court has discretion to continue the appointment of a under 19 CASA with the young adult, with the consent of the young adult. And so I think in that situation, it would be important for the CASA volunteer to discuss with the young adult how this program and how your role as a CASA volunteer and how best interest changes from the under 19 system to under the Bridge to Independence program. And then questions for attorneys. What are the situations in which I might be appointed? And so I think this it'll be interesting to see it, but I think this will really run the gamut. I think some young people will say, well, I want my GAL to continue. Some young adults will say, well, I understand that there's going to be hearings and I have to sign an agreement, and so I like to have an attorney from the beginning to help me through the process. It's possible that some young people will not request an attorney right away, but down the road, if only if an issue arises, like maybe a housing situation or a services they're not receiving, they would request an appointment of an attorney at that time. And then what is the young adult's role, a young adult attorney's role in a Bridge to Independence program? And I think the role is clear, again, as a client-directed model. And your role is to raise issues on behalf of your client in court, while also, I think, allowing them to self-advocate if they wish for services and support. As a young adult's attorney, you can request a hearing, or you can request court orders as necessary within the scope of jurisdiction I described previously. As a young adult's attorney, you can attend case reviews, meet with the young adult, answer questions, communicate with the independence coordinator and other providers, as requested at the direction of the young adult as your client. And then what if I was previously the young adult's GAL? I would have the same recommendation to really just have a conversation with a young person at that time about how your role is shifting from the best interest role to a client-directed role, and what that means when the program begins as they're shifting over. And then questions for judges. What process should the court put in place in 3A cases related to the Bridge to Independence program? So as I described, there's several requirements, duties on the department to around notice and transition planning elements that are set out in the statute. Judges should obviously provide oversight to this requirement by ensuring eligibility and talking about young adults' interest in this program as part of that transition planning process. If young adults wish to go directly into the program at age 19 or when they age out, the judge should follow the statute to ensure the petition is received at that time and the new case is opened. And then, as I think a best practice would be to, specifically inquire about housing, if that will be with the foster parents or in a different setting. And then judges could also ask at that time of the young adult if they would like to have an attorney, their attorney appointed or a GAL appointed or continued. I was saying it's probably a good idea to be sensitive. If the young adult wants a different one, they might not want to say that at that time, but judges can certainly play that role and ask that question at that time. And then these two are dimmed because those are both questions that we're hoping to talk about during the team planning process. How can the permanency hearings be informal? Where could they be held? How can the court support the active engagements of young adults in key decisions? And then this is the million-dollar question that I don't have an answer to specifically, but how far can courts go in making orders to ensure the young adult receives identified services and support? Okay, so now I want to just walk through a few resources that we have on our website. That's a screenshot of Appleseed's website. It's like way up there, kind of small, but it's at neappleseed.org/B2I. And these are all in your yellow folders as well, but I want to just kind of walk through what we have because there's a lot of it, and I want to just make sure you're aware of it when you may need it. We have a set of resources for judges, lawyers, and other professionals, and then we have a set of resources for young people as you're working with them. So first, for judges, lawyers, and other professionals, the Court Improvement Project developed a bench bar guide, and that provides a really great basic overview of the Bridge to Independence program. And then Appleseed created several fact sheets. The first is a Bridge to Independence fact sheet. The second is a timeline of service provision. That's essentially the slide you saw with the bubbles and the timeline. And then my personal favorite, the super simple Bridge to Independence and ACA fact sheet, and that provides it's good for everybody, not just professionals and young people, but all of us. It includes the basic eligibility requirements and services provided as part of both the Bridge to Independence program and also the ACA provision that I'll talk about. We also have that available in Spanish. And then we have a couple of sample court forms for judges, and I'm going to just put a hold on that because I want to have you guys pull those out and kind of walk through them. So you can start to pull them out while I'm talking if you'd like to kind of shuffle through. But in the meantime, we also have a group of resources for young adults. And that includes a separate Bridge to Independence fact sheet that is youth-friendly so that we hope you'll share with young people as you're working with them. We also have a Know Your Rights guide that we're very excited about because you have it just printed out regular, but we have it like on glossy paper that we don't always get fancy graphic design at Appleseed. So it's an actual booklet. And so we have those that you can share with young people. It kind of goes through the rights in the program and what they can do if an issue arises. And then I'll also walk through shortly, as you're looking through your folders, we have 3 sample young adult motions, one to request a hearing, one to request an attorney, and one to request a CASA volunteer. And then finally, Appleseed, in collaboration with Project Everlast and the Court Improvement Project, developed a B2I court questionnaire. So I hope you are all familiar with the youth court questionnaire where young people can provide input to the court on that form. This one is different. It's similar but different for the Bridge to Independence program. And the Through the Eyes of the Child initiative is currently in the process of making both the youth court questionnaire and the new B2I court questionnaire available electronically. So young people will be able to fill out the form electronically, and it will be submitted to judges and other parties online. Coming soon. We'll also have it available for young people in old-fashioned hard copy to provide and to complete that way as well. Okay, so hopefully, let me show you this. So this is like a zoomed up version of the Appleseed's website, and so it's a bunch of drop-down menus when you go to it. So you can see on the left that there is a section for attorneys, well, for young adults, I guess is what it says up there, and then for judges, attorneys, and other professionals. And then on the right side, we've shown you the drop-down, and that is a drop-down showing you where the sample orders and findings are as an example. So the sample orders and findings and the sample motions are available on our website. in both Word and PDF version. So on the sample court forms, a word about them. They were developed by Nebraska Appleseed. We tried our best to take off our advocacy hat and not make any assumptions, but that said, this is a new law, and so we did our best, and that is why it is available in Word version. We invite judges to make changes as they see fit if they would like to use them. And so we certainly invite you as well, as you're taking a look at them, if you see anything that you think should be different, or certainly if it's incorrect, please let us know. We did do a lot of looking across the country at what other sample motions orders look like in other states around the country that have programs like this, and the forms are based off of that in our law. So if you first pull out, I want to just kind of walk through them so that you're familiar. The first is a sample order and findings regarding the voluntary services and support agreement. Each of the sample orders and motions has a background and instruction pages. The sample orders have set out essentially the law, the statutory provisions that are relevant to the finding. This one is the best interest finding after the department files a petition with the juvenile court. So you can see that that's a pretty straightforward best interest finding. And then the second one is a sample order and findings after the permanency review. That one's a little bit longer. Again, the cover sheet kind of goes over the statutory scope of the hearing and the process. And then there's findings about notice, who was involved, and walks through aspects of the case plan. And then it includes a reasonable efforts and a best interest finding. And then there are, as I said, 3 sample motions. One is to request an additional permanency review, one to request an attorney, and one to request a CASA volunteer. These are intended for young people as an option for them. One of the judges yesterday was just saying, you know, if I get like anything from a young person requesting a hearing, I'll file one. So of course we'll let young people know that as well, but this is an option for them to let them know how they can do that if they're not represented by an attorney, how to request a hearing. So that this one also has a cover page that is youth-friendly and kind of describes the purpose of the hearing, the reason that they might want to request one, and how to request a hearing. In terms of process, we suggest to them to fill out the form and either take it to the courthouse themselves or mail it to their judge. You can see on page 2 and 3, it's a pretty straightforward request for a hearing. It allows them to provide some information about why they're requesting a hearing. And they can also request an attorney or CASA as part of that form. And then on the form to request an attorney, it describes that it's a client-directed role and how that's different. It also mentions that most likely the attorney would be at no cost to them, but it's possible that if they have a certain amount of income, they could be required to pay for part of that. It also requests that they can request that their GAL be appointed and that role would change. And then it also includes some information about that they can represent themselves and a short statement about what that means. The request for the CASA volunteer is similar, describes the benefit and role of the CASA volunteer, and it explains also that the CASA volunteers are not paid and that they maybe only have 1 or 2 young people that they're working with, so it kind of describes how that can be helpful to them as well. Okay, I think that's all. Are there any questions on that piece before the program itself, before I hand it over to Cassy? Okay. Okay, great. We're gonna just, do you want them to actually take a break or just? Yeah, okay.
So if you need to stretch, check some things out. All right. All right. Now, as Sarah said, my name is Cassy Rockwell, and I am the Director of Youth Engagement for Project Everlast. my role at Project Everlast is really doing a lot of this type of thing. So ensuring that the community has the training and the skills needed by the young people to work with them, but then also helping the young people to develop their advocacy and outreach skills and providing some technical assistance and training to all of our community-based councils. If you don't know what Project Everlast is, I'll talk really briefly about that before I jump in. We are a group of young people, 14 to 24, who have or are currently in care. We have community-based councils across the state in Scottsbluff, North Platte, Grand Island, Norfolk, Lincoln, and Omaha. And then we just added a council in Fremont about 6 months ago. We also have councils at both of the youth rehabilitation and treatment centers. Those do two things. They first provide a place for young people to have some peer-to-peer support in a safe environment. Then also to use their experience to create a better system. So they learn how to do that in a way that is safe for them and is also helpful to the folks that they're trying to share with. And that's half of the work we do. The other half is about systems change. So it's taking the things that we hear from those young people and alongside them doing things like bridge to independence and creating change, working with the department, working with community providers to create communities that really do support young people as they transition from care to independent adulthood. And the greatest example of that has been right here in the Omaha Metro about 5 years ago through the Omaha Independent Living Plan that since then has been implemented to create a really wonderful safety net throughout Omaha for young people in that transition stage. So that's really who we are, what we do, and I can talk more about that if you have questions. But what I'm here to talk about is not the legal side. I am not a lawyer and will never claim to be a lawyer. And I'm hitting buttons when I don't mean to hit buttons. Let's go back here. Whoops.
Kind of opposite of what you think.
Yeah, it is, isn't it? Now I'm messing everything up here. We're going to just use the old-fashioned way. There we go. I work with youth, but I'm by no means good with technology. I'm really here to talk about the spirit and the ideas behind Bridge to Independence and that help to develop it, but then also our hope to continue throughout the process of implementation. And that really aligns around adolescent brain development and building young people as self-advocates, and then doing a lot of youth-adult partnership ourselves in the work that we do. It's been key throughout the development of this. To do that, though, the first thing to really understand is the idea that the adolescent brain is by no means fully developed. As we know, adolescent brain research has been out for almost 2 decades now and shows that the frontal lobe, which is the decision-making part of our brains, is not fully developed in women till the mid-20s and men closer to 30. So when we turn young people out on their own at 19, that key part of the brain that really is focused on logic and reasoning isn't developed yet. And then, of course, they go out and make mistakes, and they don't have the safety net that a lot of young people in more traditional settings have to fall back on. And so we see, as Sarah mentioned, a lot of really negative outcomes for these young people, and the Bridge to Independence program is meant to soften that. So then what we know from that is that relationships are key for the development of that frontal lobe. They have to have that experiential and supported risk-taking in order to develop that logic and brain. So the ability to make mistakes and have somebody to process those mistakes with and then go out and try again. Without that, they never learn that, the positive way, the way to make those solutions, and then that frontal lobe doesn't develop appropriately, which really then makes the idea of positive youth development neurological imperative and key to them being able to develop into successful young people, not just something that we say is wonderful and nice to do, but really essential to positive development for young people. There's a lot of great other research on brain development, but I don't want to spend too much time because I want to get into the roll up your sleeves nitty-gritty discussion that we'll do in a minute. When we talk about building self-advocates, this is really key because as you saw throughout Sarah's presentation, it's all about elevating the young people to be their own advocates, to talk about what's best for them, to be the leaders on their team, to represent themselves in their courtroom. And it's making that transition from having all of these paid advocates in their lives when they're in the under 19 system to now, as adults, we are our own best advocates. And Bridge provides a transition to that. So some key things to think about when we're working with young people to build them into these strong self-advocates is to understand that it is absolutely time intensive, especially for young people who have been system involved because they haven't had a lot of practice advocating for themselves. They haven't had a lot of opportunity to do that often. So this may be the first time that somebody's asked for their opinion, or their opinion has really carried some significant weight. So we have to understand that the development of that takes a lot of time, for a couple of reasons. First, that it really requires a time investment, but then also a cultural shift for us. So as Sarah mentioned, with the way we shift our thinking as lawyers from being best interest to client driven, we must do that also as workers and as support people for these young people, to really kind of let their drives, their desires, and their unique desires shape that. We also have to understand that we have to develop trust in order to do that. Young people that have been system involved oftentimes are very hesitant to trust and believe the adults that are around them. And so in order for us to have that positive relationship, to have them trust us as that relationship person, we need to know that it's going to take time for them to develop trust in us, but then also in the process. And finally, that we must understand that it is not easy work. And I will never begin to say that doing youth work, especially youth-driven work, is easy. You can always just do it yourself and do it faster, but it's not going to have that same payoff. And then we're not doing what the program was designed to do, which is create a bridge. We're just extending that cliff. And we're not moving. What is this doing?
The left one goes down.
The left one?
Opposite of what you would.
Okay, here we go. Now I got it. Awesome. So there's a couple of different models of positive youth development. You'll oftentimes hear me talk about Hart's Ladder, which is really great for organizations that are looking at how their organization does youth development. When we look at Bridged Independence, it's more about the individual, which makes Karen Pittman's 5 C's of positive youth development as her model. There was a 6th C added by a separate researcher in the in early 2000. But it really focuses on individuals and the one-on-one mentoring relationship that occurs between an adult who's acting as a coach for a young person and the young person who's trying to develop those skills and that feeling of contribution and self-sufficiency. It's key too, because it's not about fixing those behaviors in that young people. It's about really developing their skills, their attributes, and their talents to be able to be self-sufficient. And super focused on that relationship. So I want you to go into your packet, and here's another wonderful handout for you on the 6 C's, and it looks like this. My hope is that this won't go back into your folder and then in a file in your office somewhere, but that it's taped, paper clipped, framed in your office, on the wall, above your desk somewhere, to really act as a model for when you do youth work. Before I talk about the 6 components, I want to mention the picture that we have on this slide. This is Judge Ide, who is a judge in the Hastings, Grand Island area. And Giantis, who used to be a member of Project Everlast, who has now moved on to be a foster parent herself and to do some other wonderful things with her life. Judge Ide served as Giantis' judge for almost her entire time in care, which was most of her childhood, 16 years total. And she talked often about how the judge was one of the key people that she really thought had her best interest at heart, that she trusted, that she went to. And even after she aged out, she would see the judge in the community, and you could tell instantly that there was a very strong relationship there between the two of them. And I'd like to use this picture and share Giantis' story, which I will say she has shared numerous times, and I have her permission to do so, because it shows that even somebody as a judge who doesn't have super regular contact with a young person can have a powerful impact because of the role that they play to be supportive and engaged. And that was a big thing that Judge Ide valued in his courtroom, was hearing what the young person had to say. So we look at the 6 components. A couple of key things to remember that are essential when we look at Bridged Independence is to understand that the most difficult but yet most important ones for us to work on are the idea of contribution and competency. I say those are the most difficult because those 2 skill sets require us as providers, us as adults, to relinquish control and power and give it to the young person, which also means that we're taking on some risk by trusting them to follow through on things, by trusting them to do that. But without giving that trust, we can't expect them to trust us. And also, if they never have the opportunity to try and succeed, then they can't try bigger things and succeed at bigger things. Success is the best predictor of future success. So you must kind of step back. And those can be simple things such as letting them make a phone call to a referral source instead of you doing it for them, letting them set up their doctor's appointment. And it can also lead up, and I encourage as you're working on implementing the program and you're working with these young people to get to this place, but helping them set the agendas for their meetings. When you pull their permanency teams together, when you pull the people in together around them, work with them on the agenda and then let them lead their meetings. Rather than just being a participant, let them be the active driver of their life, essentially. Yes? Yes, I sure can. I'm sorry. Get there. Let them know that you're going to be there in the room to help them, but let them get there and then celebrate the heck out of it when it happens and it goes well, while offering a little bit of coaching. Something that we do often in Project Everlast when we have young people speak is we always do all kinds of preparation beforehand and work on what they're going to say and how they're going to say it and what parts of their story they're going to share. And then afterwards, we always do a debrief where we talk about, you know, you were really awesome and I loved the humor that you incorporated throughout and people really got to see who you were. And I think you got your message across really well. Next time, I think you'll be even more powerful if you do these things. So then we build up and we're constantly coaching and coaching and coaching and coaching. And they really do appreciate that. And that helps us to also fill a couple of the other C's because that is really caring. That's really building confidence. And that's also developing their character to understand how to take that criticism and move forward. And so you really see by underpinning all the interactions that you do with young people through these 6 lenses, you're able to develop strong self-advocates and strong young people who do trust and succeed. Questions about the 6 C's? Okay, so that's really what it looks like when you work individually with the young people throughout the program. Now when we're talking about implementation as a system, that's another place that we hope we'll continue to see young people engaged and is really the intent of the bill. Here's some ways as you're looking to do that in your community to do that. And again, Omaha has done this for years. You guys have done this through years through the Project Everlast work that you've all been so intimately involved in. Some key things to think about is understanding that if we're going to have young people at the table as partners, they have to have an equal say and voice. So we're looking at the recommendations. When the Children's Commission had their advisory council, there were young people involved in that process. And they had equal voice and equal vote at the table as anybody else that was speaking and talking. We also have to understand that we need to welcome and then encourage buy-in from all of our partners. So having young people at the table is great, but we want to make sure that they have a reason to be at the table and they're the right match for that. So it really needs to align with their purpose, their values, their beliefs. For example, with young people involved in the passage in the lobbying essentially for bridged independence, it wasn't whatever young person that could come talk to senators came and talked to senators, but it was young people who often had been involved from the very beginning. So this was something that was key to them as an activist, as a young person speaking out. And so they were really able to pursue their passions and how to buy into your cause, rather than just, should come sit at this table because you have this past as a foster youth. Does that make sense? The other thing is to make sure you have expectations for young people. And I'll admit, there's times where we hold young people to expectations, and once we implement that accountability, they walk. That's fine. I would rather see that happen than just constantly say, oh, it's okay, it's okay, it's okay, rather than providing them opportunities to learn. So again, there you go back to that 6 C's model. Provide that it was expectations and that accountability in a considerate and caring manner, and young people will rise to those expectations. And finally, to think about the simple logistics of the work that we do. And again, this is another part of that cultural shift. And looking at, are our meetings held at a time, place, environment, atmosphere that is comfortable to young people? And if not, how can we balance the line between professionals that have lives and families outside of the 9-to-5 time that they need to be respectful to, and young people that work during the day or go to school during the day and can't meet before 3 or 4 o'clock in the afternoon? How can we find a balance there? Some other things to think about is to, and this covers several of the things on this slide, is to not make assumptions. Oftentimes when we bring young people to meetings, they will, we'll see them, and this is something I have to watch myself from doing. We'll see them putting their head down on the table, doodling, texting during the meeting, and immediately we're like, well, why are they even here? They don't care, right? oftentimes what I find out when we have discussions afterwards, again, doing the coaching, that there was something that happened either prior to that meeting or during that meeting that caused that disconnect from what was going on. Some things such as I had a huge blowout with my boyfriend or my mom or da-da-da-da before the meeting, so my head really wasn't in the game. Okay, well, I needed to check in with you beforehand to make sure, once more time that you were ready to go. Or there was something said, terminology being used during the meeting that caused them to shut down. A common one is the word, using the word delinquent when you're referring to young people, or not delinquent, juvenile when you're referring to the young people in the meeting because they connect it to delinquent. We think of it as just a term to refer to the young people at this time, but they automatically connect it oftentimes with that delinquent language and then apply it to themselves, which I would shut down too if that's how I was being referred to in a meeting. So thinking about your language and your communication, which touches on the last point on this slide, which is understanding that you are really working with multiple cultures. You're working with our professional culture and you're working with the culture of young people. And those two cultures have different ways of relating, different ways of communicating, and you need to facilitate an environment that allows for asking questions, allows for clarification, just as you would working with any other culture. And also understanding that if we want to engage people, we need to provide them opportunities to take more and more ownership as they move on. I always like to put this slide in when I talk about youth engagement because people often are very well intentioned to include young people, but make some common missteps. These are those common missteps. Things like, we just have to have young people at the table right now. Like, it's so important to do this, and we really think this is awesome, so let's get them here now. And we bring these young people to the table, and then they're just there. Training needs to occur on both sides. So the young people need to be prepared to sit in that meeting, as well as the adults need to be prepared to have young people sitting in their meeting. And ensuring that you have clear expectations, clear roles for those young people, and that those clear roles and expectations aren't simply busy work. So they're not just the easy things or the things that we think that they can handle, but they're aligned with the young person's talents or their sparks. So maybe you have a young person who's really interested in going into administrative assistant type of work. And so they love organizing, very big on organizing. Have them facilitate registration for some event. Have them lay out your tools that you're going to be developing. Match those things with them. Use it as an opportunity to develop their skills as well as have them be an active member of the group. And I touched on this next one already, and that's making sure that you're not just simply using them to say, well, let's just have you talk because you're the former youth that's at the table. Or we need to have a young person come talk about this because that will make our message more powerful. But really ensuring that if they are to be our spokesperson, that it's connected to their values, their beliefs, that they're doing so in a safe and positive way, and that it really is beneficial to the cause, not simply sharing a story to have a story shared. And finally, ensuring that if we are going to have young people at the table, that it's young people, not just let's get a youth to the table and call that youth involvement. There's a whole lot more that goes into it. I sped through that because I want to get to the next part, and I want to make sure you have time to get to the next part. But before we jump there, let me talk about a few resources that are available to you. Project Everlast website is one. There's information on how to get involved in our councils or the work that we do, as well as a service directory that we're constantly building. It's by no means all-inclusive, but we hope to keep adding on to it, where young people or those working with them can go enter a service area and then a specific type of need area, and it'll pull up resources that exist in their service area around that need. If you have or you work with an organization that's not listed when you do that search, let us know and we'll get you added. Jim Casey has a ton of wonderful things on extending supports and services, on adolescent brain development and on youth development. So it's a great resource for a lot of reasons. This next two really have great resources around permanency. Permanency is a big piece of B2I. So there are one great resource that's on both of those websites are permanency packs, which are opportunities to develop those permanent connections and are essentially a contract between an adult and the young person promising certain types of supports. And we all know research shows if you have people sign their name to something, whether that contract has any legal merit or not, you see greater commitment to the cause. And the rest are all resources around positive youth development, both as an organizational level and as an individual level for you to look into. Before we move into the next activity, I want to pause if there are any questions, thoughts, concerns. Yes. Beautiful. Great. Yes.
I was just curious, are there any plans going forward once this program gets more established to have maybe youth who are participating in the program mentor or answer questions for youth who are considering being part of the Bridge to Independence? Just because in my experience with former ward funds and things like that, a lot of the clients that I would work with were really skeptical about wanting to continue relationships with the Department of Health and Human Services or have the judge, you know, involved in their business from here on out. And maybe if they could hear some positive experiences from people their own age, that might encourage them to be a part of a program that could ultimately benefit them.
Yeah, that's a great idea. Formally, no. Informally, yes. Through the councils as one. Also, we partner with Central Plains Center for Services, or PALS, and they have youth consultants on staff that are former alum that also work with us in a supportive capacity for a lot of our councils. And so some of them may be involved, and we'll obviously have council members that are involved in the program. That will be a place to do that. But as formally, do we have that in place? No. But yeah, it's a wonderful idea. I love it. And we're always looking at how can we do more with that mentoring piece. Other questions?